What's going on, everybody?
Who is that cat?
Archer.
You're just gonna stare at me? Oh.
I am, Walrus. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy to have you guys here. We're getting to watch. Well, I was given the heads up from Alex from Our Nevada Judges that he was going to upload parts 1, apparently also parts 2, of the most recent Hillygus hearing, and he told me it's got some gold content. So I'm excited for it. I haven't seen any of it except for the minute preview that he had on there. So we're gonna get right into it. I don't know how long I'm gonna be streaming. It was a long day today, but I'm curious. Let's go ahead and check it out. All right, I'm excited. Hope you guys are excited too. I think it's gonna be a lot of fun. Let's get the show on the road.
You swear or affirm the answer you just gave to the court with respect to the issue of potentially abandoning your mom after the surgery was truthful?
Absolutely truthful.
Thank you. You may put your hand down.
Judge, may I cross-examine on that?
Uh-oh.
The state of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Happy New Year. We're on the record in state of Nevada versus Roger Hillygus and Stuart Ante, both of whom the court acknowledges are here in court. Mr. Ante is here with his attorney, Mr. Silverberg. The state is represented by Mr. Steggy. Good morning to you all.
Good morning, Your Honor.
All right, the court has excused the participation of Joe Goodnight from this hearing. Reason being, we all remember that Mr. Goodnight was appointed for the limited purpose of assisting, counseling, if asked, Mr. Hillygus with any issues relative to this case being resolved. This hearing is not about that. So Mr. Goodnight did not have to be here. Before we handle the state's several motions for the court to admit other act evidence, a couple rules of engagement and logistics comments. First, trial begins Monday, February 22nd, 9 a.m.
January, correct?
Beg your pardon, what did I say, February?
Yes, sir.
Rewind. January 22nd, 2024. 9 a.m. Now, what that means is the jury veneer will be brought up just as soon as close to 9 o'clock as we can. So counsel and the defendants should be here at the defense table by 8:30. Once everyone's here, the court will check in, and now once I receive word that we're ready, the court will leave the bench and then bring the veneer up, and we will proceed with jury selection. So that all happens Monday, January 22nd, beginning at 9 o'clock. The normal court day thereafter will be 9 to 5, breaks in the morning, breaks in the afternoon, lunch break of about an hour or 75 minutes, and other breaks as needed for comfort. That's 1. 2, I do want to have a final pretrial conference. When? Wednesday, January 17th at 9 a.m. Also known as the Wednesday before. This is quite usual and typical for Department A to have this type of a hearing the Wednesday before. Several things happen the Wednesday before the Monday trial. In our case, I will personally...
Okay, so I'm looking at the description. Okay, this is an evidentiary hearing on the admission of other act evidence, which I assume is probably like prior bad acts. All right.
Hand out the
That makes sense.
jury veneer, the anonymous jury veneer, with information I redacted, but everyone will get it at the same time. You will recall from the court's order entered recently, consistent with the hearing we had, generally the information redacted will be the prospective juror's name, address, email, phone number, place of employment, or other information which would identify them if anyone was of the mind improperly.
As far as I know, it's not going to be streamed. It's going to be
What will not be redacted is their age,
recorded and uploaded.
their gender, their zip code, if they answered whether they have prior felony, law enforcement, children, parents, things like that. So it's really the identifying information that will be essentially blacked out. You all get it at the same time. You all can use that. When the case is over, that information needs to be returned so the court can destroy it. One question I'm still trying to determine the right answer to is whether Mr. Hillygus can take that information with him back to the Washington County Jail. Right now, the court's leaning toward yes, provided we get it back when the trial's over. I don't want him to be burdened or disadvantaged by not having the information available to him from Wednesday through jury selection. All right, so on Wednesday, on the 17th at 9 o'clock, you'll each get that. Second, Joe Goodnight is ordered to be here at that hearing because the court will conduct a second Fry versus Missouri canvass. You'll recall the court did that when we were set for trial previously to determine what offers have been extended to resolve this by the state, to confirm that the defense has received them, considered them, and rejected them. That shouldn't take long. Third thing that will happen is I will remind counsel, and I'll remind Mr. Hillygus, where you can stand when you are examining witnesses, where you can stand when you're making opening statements, where you can stand when you are making closing argument, where you can stand while you are conducting voir dire. No one is ordered to stand at the podium, but it's usual, customary, and generally good practice to do so. The podium, as you'll see in more detail Wednesday at the final pretrial conference, will generally be here in the, we call it the well of the courtroom, a few feet in front of Ms. Stubbs, the court reporter. Department 8 has a 1 arm's length rule. Generally stay behind the podium, or if you're going to move to the side or in front, be within a distance where you can reach it. In other words, within a few feet of it. You're not allowed to go up to the jury box at any time. You're not allowed to approach a witness without asking the court's permission. You're not allowed to approach the court clerk to get an exhibit without the court's permission. You're not allowed to approach the court reporter or the bench without permission. Standard, nothing new about any of this. With respect to Mr. Hillygus, he has you, sir, have a constitutional right to remain silent. To testify in your own defense. None of these fellows, the other attorneys, can subpoena you to testify. You can invoke your Fifth Amendment right. On the other hand, you as well have a constitutional right to testify under oath, to truthfully answer questions, or in your case, you can narrate. We'll talk more about this on the final pretrial conference Wednesday the 17th. But if you decide to testify in your own defense, after listening to the state's case, and I'm actually going to have Mr. Silverberg go second, even though Mr. Hanty is the B defendant, but to move the case along and to assist you in observing what occurs before, I'm going to, unless there's objection from Mr. Silverberg,
Your Honor.
you want your client to go third?
Second. Well,
Second to
first,
the defense lawyer.
Yes.
Well, you have that right. You have that right. I was thinking more in terms of Mr. Hillygus might benefit from the approach and the professionalism that would be expected by defense counsel, but
I appreciate that, Your Honor. My interest is Mr. Haney.
understood. Okay, so let me withdraw what I just said. So what happens, Mr. Hillygus, is this. After the state puts on a witness, no, let me back up further. When there's something that will occur in court, where the state goes first, and then the defense goes second, you will be the first up for the defense. When you're done, Mr. Silverberg will go on behalf of Mr. Hanty. So for example, when the jury pool comes in, and I welcome them, and I indicate that the state may stand up, identify who they are, or who they represent, and Mr. Steggy stands up and says, I'm Amos Steggy, Deputy District Attorney, I represent the state of Nevada. He sits down. Then I invite the defense, Mr. Hillygus. At that time, you should stand up, look around at all the people in the courtroom, say, my name is Roger Hillygus, I'm representing myself, I'm one of the defendants in this case.
All right,
Make it
let's
simple.
speed this up.
Then I turn to Mr. Silverberg, he stands up, he says, I'm Ian Silverberg, I'm defense counsel for the co-defendant here, Mr. Stuart Hanty. And then maybe Mr. Hanty stands up, or Mr. Silverberg just points to him. So that's an example of you.
Oh God, of course he did. Diver Dan.
Another example would be, after the court conducts questioning of the potential jury, known as the voir dire process, the court invites the state to voir dire the panel. And Mr. Steggy, presumably, he may do it from his counsel table, but more often he put the podium or lectern in the well and ask questions of the whole group. When he's done, he sits down, then the court invites you. And you stand up, you come over to you can do it from your table, or you can come up here into the well and ask questions of the people. Bear in mind, the order the court filed not long ago on permissible voir dire questions. This is a question and answer session designed to determine whether somebody can serve fairly and impartially. It's designed to determine if they have any bias. It's designed to determine if they know anything about the case, those type of things. It is not a time to educate the jury or potential jury on your view of what the evidence will show, on your view of the criminal justice system, on your view of the court's jurisdiction. That is not what the voir dire process is for. It's simply, importantly, but simply designed to determine if a juror can be fair and impartial. Occasionally, attorneys and self-represented litigants forget that, or they don't forget it, but they ignore the court's rule and the law on that, and I rein them in. The first time with a polite reminder, the second time with a stronger reminder, the third time I shut them down and say, you're done, no more questions. So we're not gonna get to that point with anyone here. We're just gonna ask questions consistent with what's allowed. All right, so after you go, Mr. Hillygus, Mr. Silverberg goes, and then the veneer question and answer session is over. What happens next is we take a break, all the people go out in the hall, counsel and you, Mr. Hillygus, review your notes, I come back on the bench, and then each side gets to exercise peremptory challenges. There will be 12 jurors plus 2 alternates in this case, 14. 24 people will be essentially called into the box. Each side can excuse 4 people plus 1 alternate. But 24 minus 5 and 24 minus 5 collaboratively equals 14. There are 2 defendants. So the way it will work with the 2 defendants is, you, Mr. Hillygus, gets to strike 2 people, and Mr. Hanty gets to strike 2 people, and then you have to collaborate on the alternate. If you cannot collaborate, I'm not really sure what happens. I don't know, I've never had that happen before, but usually you can agree who the alternate to be peremptory challenge can be. If you can't agree, I'll figure out what the law provides. Unless
A lot of this is procedural stuff on voir dire,
I don't have any experience.
okay,
voir dire.
Not that.
okay, it doesn't come up very often, but I'm sure there's a rule, a statute, or common law, so I'll figure it out if it gets there. All right. Once we then have the jury seated, the court thanks and excuses everybody else. Then we have 14 people seated right there.
I mean, he has to obviously explain the procedure
Opening
ahead
statements
of time.
are designed to be a roadmap of what you believe the evidence will show in the case, as applied to the law that you believe the court will give. Mr. Steggy goes first. Essentially, he says, ladies and gentlemen, good morning. Once again, I'm Amos Steggy, prosecutor. In this case, the state intends to prove, or the state believes the evidence will show, or he will tell his story on what he believes they will see in this case. When he's done, you go. Mr. Hillygus, you get to go second. So typically, again, you would stand up, you get behind the podium, you look the 14 people in the eye, you tell them good morning or good afternoon. Once again, I'm Roger Hillygus. I believe the evidence in this case will show. We believe, it's my view that the evidence will. Again, it is not an opportunity to express views that are not designed to provide information to the jury on what to expect in the trial. It is not a time to make a statement to viewers watching in the courtroom or watching online. It is not designed to contest jurisdiction. That is not what opening statements for. When you're done, Mr. Silverberg goes. When he's done, so maybe you'll have breaks in there depending on how long this takes, what time. We might not even get past this point on that first day of trial. That might be it. And the first person to testify evidentiary might be Tuesday morning. Do you have a quick question?
Yeah.
Can the opening statements be postponed to the presentation of the defense?
I believe so. I believe the defense can reserve and need not make an opening statement if they want to. Yes.
They preserve that for their case in chief.
You can preserve it as unusual, but it's absolutely allowed and contemplated by statute. All right, so then after the opening statements go, or if there's a deferral, the state calls its first witness. Person comes in, oath to tell the truth, questioning begins. When Mr. Stagey is finished with his questionings,
Hey, Chuck. Long time, man. Hi, Artie. Can I ask you a question? Do you use OBS to use your streams? I hear well. I am currently using OBS, but I might be switching to another platform. It's called Prism Live Studio. I haven't decided yet, but I'm kind of like working with the kinks with it. But for right now, OBS has been my go-to.
questions. All right, so Mr. Hillygus, Mr. Ante, just so we're tracking here. After the state calls its witness, Mr. Hillygus, you can cross-examine. Mr. Hillygus, do you understand that? Could you answer please out loud?
Yes.
Okay, and then, so when you cross-examine again, you can do it from the defense table if you want to. And if you ask the court's permission to remain seated, I've done that before, allow people to examine witnesses, see the position from behind the defense table, as long as they're speaking loudly, clearly into the microphone. When you're done, Mr. Silverberg goes. When he's done, the court then allows the state an opportunity to redirect the witness, and then recross by you, Mr. Hillygus, recross by Mr. Silverberg, and then eventually that process stops and the witness is excused. We go through that until the state is out of witnesses, going to take a few days presumably. At such point, the state will rest its case in chief. The court will then take a break to allow you to consider the evidence, consider your position, bearing in mind you have a right to testify or a right to remain silent. Then we'll come back outside the presence of the jury, and I will ask you whether you'll be testifying. And if you testify, then the jury will come back in, and I'll say, Mr. Hillygus, you may proceed. And you'll say something like, Your Honor, I'm going to be testifying in my own defense, in which case I'll have you brought up here, administer an oath to truthfully testify and answer questions on cross-examination. And then when you get up there, you can tell your story fact-based in paragraph and sentence forms. You have to keep it fact-based, not go ahead.
If the state has not proven all elements of the crime at the end of their case.
Oh, God. Oh, boy. All right, here we go. All right. We're 18 minutes in, and now we're getting somewhere.
A motion to you to dismiss the case on acquittal because they have not proven their case
True.
beyond a reasonable doubt.
True. And of course, that happens outside the presence of the jury after we take a recess, at which time you can say, Your Honor, I'd like to at this point make a motion pursuant to whatever rule of criminal justice, criminal practice, statute, common law you believe applies. Tell the court the basis. When you're done, the state gets to respond, and then you get to reply, then I'll make a decision. The co-defendant can make a motion on its behalf if it chooses to do so, and the court will address it if and when that occurs. All right. But I want to focus for a moment, if you end up testifying in this case, if the case is not dismissed, and if you decide to testify, the way it works generally with a self-represented litigant is they get to essentially narrate their story, factually, of what happened. Now, you have to understand that when you are speaking, you're under oath. When you're speaking, either counsel can object to whatever you're saying on any rules of evidence that would normally apply to a traditional question and answer exchange with a witness. If there's an objection, I need you to stop talking, and then I let you respond to the objection, then I make the decision. And if the objection is sustained, you can't continue on whatever issue, fact, that line was, but to move to something else. If the objection is overruled, you can continue on the subject matter that you're on. But I want to bear in mind that the rules apply to you, that you can speak to fact-based, evidence-based views of what happened, your recollection, what happened, what you read, what you prepared, what you understood, things like that. What you can't do is, again, stray areas that are not fact-based. All right, when you're done, making your statement under oath, Mr. Stagey has a chance to cross-examine you. When he's done cross-examining you, Mr. Silverberg has a chance to cross-examine you. When he's done cross-examining you, you have a chance to speak again in response to any of the questions that they posed to you. And then eventually we're done. At that time, we take another break, and I ask that Mr. Silverberg meets with Mr. Hanty and make a decision whether he'll be testifying in his own defense. I examine Mr. Hanty outside the presence of the jury, and whether Mr. Hanty testifies or not, we'll see what happens. When the defense is done, the defense rests. Then if there's any rebuttal witnesses, the state, if it's legitimate rebuttal and not just something where the state wants to get the last word or should have had it in its case in chief, then we'll be done with the evidence. Meanwhile, during this trial process, we're taking a couple hours here and there to go through the proposed instructions of law. So let me talk to that point for a minute. So counsel, and this applies to you, Mr. Hillygus, no later than the Wednesday pretrial conference, please have submitted your proposed jury instructions. And or meet when the court goes off the bench Wednesday and discuss among yourselves the proposed instructions of law. This is typical, traditional, to try to work out among counsel those for which there's no disagreement and those that are legitimately at issue. But the instructions of law, the court should have before the trial starts. So if I'm directing you to have them submitted to the court by the Wednesday before the Monday trial, that means I'll have a chance to look at them Thursday and or Friday. And then during the trial, we will get them in signature-ready form. If somebody wants instructions of law that the court declines to give, the offering party makes a record, and it's part of the file that this was offered by Mr. Hillygus. The court rejected it. It was offered by Mr. Stakey. The court rejected it. Offered by Mr. Silverberg. So it's clear to any appellate review tribunal that that instruction of law was not given. And verdict forms too. All by Wednesday before the Monday trial. When the court has determined the instructions of law, we set the closing argument, jury comes back in, I instruct them on the law, closing argument occurs, then they deliberate. Mr. Stakey, any questions or comments about what the court has just said?
Only that law does not allow for directed verdicts in criminal cases. So the hope that the court would dismiss a case at the close of the state's evidence is misguided, not lawful.
At the end of the entire case?
At any point, the court cannot take this case away from the jury. I'm not here to educate the defendant on.
But you can educate the court. There's a rule that does allow a defense to argue to the court that there's insignificant evidence to justify a jury verdict.
No, there's a statute and an interpretive case law that allows the court to give an advisory verdict or advisory instruction to the jury. That's incredible.
I see.
Idea that's a civil rule
okay, hold on.
that you're referring to.
Okay, right. You can tell it's confused.
Yes.
An advisory verdict that, in the court's estimation, the state has not met its burden to prove that all elements of the crime with evidence beyond reasonable doubt.
An instruction to the effect of, I advise that you are not bound to follow my advice.
Okay. The request for that is made at the close of the state's case in chief, I believe. Mr. Silverberg, do you know any differently?
I pursue those motions, Your Honor. I disagree with the state on the court's authority to do that. There's an advisory instruction, and then if the jury does not follow that, the court then has the jurisdiction to dismiss the case.
Well, I've been asked to set aside a jury verdict on a guilty verdict before, and so I know there's a rule and there's a procedure. But
It's misguided for Mr. Hillygus to believe that civil remedy is available in this criminal case. He would, of course, have to bring the motion himself and have the support for it, including the legal support for it. As, of course, Mr. Silverberg, who I have no doubt will be prepared if he.
okay.
No, I have no other question.
All right, so let me summarize in response to Mr. Hillygus' question, a more accurate response. Counsel have reminded the court that the law provides, in the event a defendant believes the case hasn't been proven against them, to ask the court to provide an advisory instruction to the jury that it is, I don't know what the word is, encouraged or advised that the court believes the state hasn't met its burden on all the elements of the charge. And the jury can then take the court's advice or not. Now, after the verdict comes back, there is a procedure on motion for the defendant found guilty to seek the court setting aside the verdict. So there's that law that's out there as well. All right.
Okay.
Any questions? Let's go to you, Mr. Silverberg, on anything the court said with respect to the order of the trial or the process involved.
Mayor, the only thing that I have concern, and I would just speak for Mr. Hillygus for a moment, is normally when someone's in custody, if Mr. Hanky were in custody, we make sure that they have proper clothing, and that the sheriffs and the bailiffs and those in charge of him make sure that he's not shown in front of jury to be in shackles or any such things. So I don't believe our office is in a position to get his clothing, but
That's been handled. I checked in with the sheriff's office as recently as this week to make sure that
Oh yeah, I forgot that he wanted to have a tailored suit for his trial.
those nice slacks, shirts, ties, shoes, socks, belts have been ordered in his size, and we'll have them dressed appropriately for trial.
And of course, the only reason I bring that up, I don't represent Mr. Hillygus, but anything that affects Mr. Hillygus could potentially negatively impact Mr. Hanky, so that's why I bring it up.
Understood?
Thank you, Your Honor.
A few of the things that we just went over, I'll cover again, or respond to any questions at the final pre-trial conference the Wednesday before trial. I want to move now. I'm not sure if you're raising your hand because you have a question, Mr. Hillygus, or that's just what you're resting. Okay. All right. So let's move now to the direct motion the state filed a few weeks ago, seeking to introduce other act evidence against Mr. Hillygus. Now, let me start by saying, so, Mr. Hillygus, there was no formal.
Ladybug 77, thank you for the $5. I think the primary charge is kidnapping of a person over 60, or kidnapping of a protected person. I forget how Nevada does it, but a kidnapping of the elderly is kind of like the primary charge. The question is, he allegedly kidnapped his own mother from a nursing home.
Response to this file that I saw, but I set this for hearing anyway, because the law contemplates an out of the presence of the jury hearing. The court has to make certain findings in order to allow the state to bring up this type of evidence, and I wanted to make sure that you had a chance to be heard and the court to consider this.
I've been having a problem with notice and receiving documents. I just received the notice of this hearing 2 days ago, so I've not had sufficient time to prepare. It has been moved up instead of out, which is not normal. And for those reasons, I do have documents that I'd like to put on the record, and I'd like to provide them to the clerk. And I'd like to read what they are, each one, so that the court knows what I'm providing.
Well, don't do it yet. Hold it for a second. So the documents you brought in response to this request by the state to have the court allow them to introduce evidence of other things you've done or haven't done?
These documents are related to the case, and without being able to explain to you what they are, if you'll give me a minute, I can go real quickly about what they are.
Oh boy.
And that way
Here we go.
Well, how come they haven't been, if you want the court to consider them, and you want the state to consider them, why weren't they filed in response to this motion?
I object to this hearing. I object to the order that you provided for me to have the ability to defend myself, because in that order, you've given the Washoe County Sheriff's Department discretion to deny me my ability to defend myself through the tablet, which has been only given to me for a short amount of time during the middle of the day, when I have 2 meals that I have to eat, when I have to take a shower, when I have to get medications, when I have to get out for tier time, when I have to make a phone call. They're not providing me the tablet at night when I need it the most. Not late at night, not after midnight, but say from 5 o'clock until 11. I'm being denied, and I've documented every opportunity that they've denied me the tablet. The tablet, sometimes the battery doesn't work, sometimes the internet doesn't work, sometimes the fast case, it's called, is a software program that that I have to utilize to defend myself. It doesn't work, and I've documented all these opportunities, and the state knows this because I put it in emails from the sheriff department out.
No, I haven't, Riku. I don't know what to do to pattern them.
It's a due process violation to defend myself properly. And that's part of what these speak to as well. I'm not getting documents. It took 10 days from the date something was file stamped until I received it. I'm not getting proper notice. They can have that delivered to me that same day. 10 days later is a violation of my rights to notice and service and to be able to defend myself. So it is a due process violation, and I object to your order giving the sheriff's department discretion to deny me a tablet, because I'm just one person that's trying to defend myself. I don't have a whole team of investigators and paralegals and attorneys working on the case. And part of my documents explain all the violations that the state has done against me to be able to defend myself. One of them is I'm not allowed to mail out. I tried to get an envelope to be mailed to the Department of Justice, and I was refused to mail an envelope regarding a complaint, a whistleblower complaint about
Oh my God.
the treatment that I've been receiving while in this jail, and the retaliation and the discrimination for exposing and explaining some of the violations that I've observed, and some of them have affected me personally.
Okay, hold please. Let me ask
So
you
if I
this.
can't mail out to the DOJ, how can I mail out to this court?
Well, let me ask you this. Are you aware today the state is asking the court for permission to bring in evidence at trial of other things that they believe you've done or failed to do that are relevant to the charges here? You're aware that's what we're here to do?
So what I can explain to you is,
Judge, the short answer is yes, he is aware. He was served with a motion, and we can continue with, I mean,
objection.
there's a long history
Objection.
of,
Hold on a second. Go ahead.
pardon my interruption, but there's a long history in this courtroom and in this courthouse of Mr. Hillygus obfuscating and delaying and being dishonest with the court. The short answer is he was served with this motion properly according to the rules of evidence, to our rules governing the filing of motions. In every instance in which we have served him with either discovery or pleadings, he has played these games where he refuses service. Nonetheless, the documents are handed to him by sheriff's staff. So the short answer is yes, he has received notice. We're here for the hearing that I requested on my motion. I suggest to the court that we proceed directly with it because we are now 35 minutes into this 2-hour block apportioned to this with witnesses available for this.
Well, that was mostly because the court wanted to explain how the trial's going to go.
I would object to him answering for me. I would object to him explaining that I've been dishonest to the court, which is a false allegation, and it's causing a bias and a prejudice against me by him making these comments that I've been dishonest to this court. I have not been dishonest to this court. Everything that I've been provided has been documented. So I'm telling you, I write down when the document is file stamped, when it's been mailed, when it's been received by the sheriff's department, and when it's been delivered to me. And so what I'm telling the court is I'm telling you what's the facts of what's happened with the documents.
Okay, but let me ask you this. Let me ask you this.
Oh yeah, he's loading up, Pope.
You're aware, right? You're aware that the state is saying, Judge, please let us use other act evidence, other activity, other matters, other information. Normally, if the state seeks to bring a criminal charge against somebody, the person can only be convicted if the evidence before the jury, in this case, beyond a reasonable doubt, reflects that a crime was committed and that person committed it. However, there are occasions where the court, outside the presence of the jury, makes a determination that the accused has done other than any witness, but in this case, an accused has done other things that are relevant to, not unduly prejudicial to, and otherwise should be allowed to be introduced in this case of other conduct. That's an exception to the normal rule. That's what the state wants to do. They have a handful of other activities that you did, engaged in, or involved in, that they're seeking the court's permission today to allow them to introduce in this trial.
I would object to the relevancy.
Well, hold on, hold on.
These aren't criminal acts.
Okay, well, we'll get to whether they come in or not if the state has made a proper showing. But you were aware that the hearing was essentially about this today. Is that fair?
Not today. I absolutely did not.
Oh, come on.
They filed a request and the court set a hearing?
I knew that they filed the document asking for a hearing, but I did not know that the hearing was today until 2 days ago.
Okay, well, when that motion comes in, your job is to review it and be ready to take a position on it if you're gonna have one. You know, that motion was filed in mid-December. The trial's coming up mid to late January. It seems reasonable to the court that you do a hearing the way you set. The court just finished a two-defendant criminal justice trial just before Christmas. So we set this essentially within a day or two of the earliest the court could possibly get people in, so you know the court's ruling and could prepare for trial. Mr. Silverberg.
I just want to be clear about something, because Mr. Hillygus indicated that he was served a notice of the hearing, but I'm not sure if he was served I know the certificate of service says that he was served by e-flex and hand delivery of the actual motion itself. And it sounded like he didn't get a copy of the actual motion, but rather a notice of the hearing. And I'm well aware that the certificate of service says it was delivered by hand delivery, but I'm just listening to Mr. Hillygus, and of course this again could happen.
Well, I haven't heard him say that he didn't get copies of the motion, so I've heard enough on whether we're gonna proceed now. We are, and so here's what happens. Mr. Stakey, it's the state's burden to show to the court that the information you're seeking to admit is relevant, that you've proven by clear and convincing evidence that it occurred, and that its relevance is not such that it would be unfairly prejudicial to the party against whom you're offering it. So what exactly, summarize for the court what you're asking for, and then let's get to the nitty and gritty.
So, in summary, as to,
This is just as to Mr. Hillygus, it's not as to Mr. Hanty, right?
Yes, and Mr. Hanty has very little to say, I think, about this. We've already had my motion work on bad acts as to Mr. Hanty. But as to, the court history of the defendant in the GR/PR cases, I seek in part to introduce in this case.
Right now, for people that may not know what that means, we're talking about the guardianship matters and the probate matters.
Yes, which are really, they grow out of the same sort of set of facts. To provide, so as the case currently stands, what the jury would hear is the defendant came and made claims that he was either rescuing his mother or his mother stated that he wanted to leave. That is something he said in his interview with Detective Jenkins. But across the guardianship history, I seek to introduce his financial motive or financial intent, and that comes through testimony of
Who the heck is eating?
Who will set out in summary that beginning in 2013, when the defendant and his wife began to be in arrears on their own home in Dayton, Nevada, they then moved in with his mother and father. Financial issues became, issues with the commingling of funds of the trust where Mr. Hillygus was. the trustee of his parents' trust, commingling began to occur. The defendant spoiled or spent, I believe it's 80% of the cash assets of the trust when he used the trust assets to pay off his parents' house against court order in order to make the house his, the financial motive to basically steal the house from the trust. From there, there's a whole history of the defendant misappropriating the funds of the trust, showing his financial motive to his belief that if he has his mother, he then therefore has his the financial piece. And that is demonstrated in this case by the defendant serves these bogus sovereign citizen documents on hers.
There it is.
Hers, at one point, the defendant was receiving, his mother had a pension from hers. He was, as the trustee, in control of that. That was eliminated by, or taken away from him by court action.
Okay, so yeah, I forgot some of the backstory. A lot of the backstory had to do with Hillygus and his sister having substantial disagreements regarding the care of their mother. There was also allegations of potential things about the estate, mom's estate, and inheritance and things like that, I believe. But a lot of it was dealing with severe disagreements between siblings on the care of their mother.
Of his misfeasance, malfeasance, as well. In this history of the guardianship case, the house, he had to be evicted from the house. It took.
Yeah, I think that's why. Oh, that's right. I think that's why we're here. Is that the prosecutor wants to bring in issues related to the guardianship matter between Hillygus and his sister. He wants to bring that into evidence, and that's what I think that's what this hearing is about specifically.
3 attempts to evict the defendant Hillygus from the house.
They were worried he might be armed.
And they were worried he might be armed, and he barricaded the door. He nearly got himself in some more serious trouble by his actions. Again, and he told the officers, "This is my house." In truth, in fact, as a legal matter, that house belonged to the trust. Other aspects of this, well, that's also borne out in this case that these bogus documents were also served on the realtors who were handling the sale of the house. The house was ordered by the court to be sold so that the proceeds could be used to support Mrs. Hillygus' care, including at Stone Valley. That final closing was meant to happen the day after the defendant committed this crime, the day after he took her from the home. So that sort of financial motive across the guardianship, and it's probate because the father died.
So, res gestae, to explain the story, the backstory to why he was at the Stone Valley with documents that the state maintains were unlawful, and to explain his conduct. Is it indicia of a motive, a plan? Is it something else?
Well, so the financial piece, I think it's clear motive, right? His belief that if he had his mom, then he would have access to her funds, that then if the house would again be his, he basically, the bogus documents purport to undo everything that the court has done, sort of establish that his motive is not, as he says, she was being treated poorly or she wanted to go, but his actual and factual motive was
Financial.
to continue to rip her off.
Okay, what else?
Also, within that GR and PR case, he continued to say, as he does in this case, that the court has no jurisdiction over him. He has numerous statements and actions evincing that he does not believe the court has authority over him. Now that is relevant, right, as to his intent. I must show for kidnapping and burglary an intent to unlawfully take her out of the state. And so his prior history of making statements that this court has no jurisdiction over me, I mean, this action is really an extension of that, He goes to court, he loses, he overspends or wastes the liquid assets of the estate. The court sanctions him for that, removes him as guardian as as the trustee and as guardian of the person of Mrs. Hillygus because of his actions. The court then declares him a vexatious litigant, and when he, this is an extension of his rejection, as stated throughout, rejection of the authority of the court, and it really undermines this idea that, and the idea that he thought it was legitimate. Oh, I'm just a I don't know what this is. I thought you could just get on the internet and get a jury verdict that from another state that undoes that. All of his history within litigation, I mean, it's fair to say this has been going on, his litigation in this district for 10 years.
Thank you, Manny, for the $2.
At pro per litigation, as well as he was represented at times too. So that sort of undermines really undermines his claim that he was sort of duped by this, and it also explains his true motive or intent. His intent is to subvert or defy the numerous court orders out of the family court.
Okay, what else?
So that's sort of the family court piece. I want to touch on one additional thing. There was a day in court where the day that the court removed him as the trustee, but before the order could be filed, the defendant quickly went to the bank holding the assets of the estate and withdrew $15,000. That sort of in cash. And that action, again, goes to this last point, his intent to defy, right? His true intent is to defy a court order, not to do anything beneficial for his mother. Moving to another section, testimony from Robin Renwick, that being the defendant's sister, evidence. Motive.
Oh no, they want to bring his sister to testify. Ooh.
Evidence that, I believe the date is in 2007. Where Mrs. Hillygus had, at the time the defendant was a caretaker of his mother, was being paid out of the trust and was living in his mother's home while his home was he was not on the mortgage. She went in for a pacemaker procedure, and when discharged, Roger called his sister and said something to the effect of, I don't want to care for her anymore, you have to go pick her up. Again, refuting or rebutting the claim of rescue or benevolence in coming to get his mother from the nursing home. The sort of abandonment is what I called it in the motion. I think that would be.
Well, it's a pretty strong word, but you're suggesting that if evidence of that exists,
yes.
it negates or refutes the position of Mr. Hillygus
Yes.
that his motives were pure when he went to pick up Susan
Yes.
from Stone Valley.
Yes,
right?
and his motive was, yes, and I agree it's a strong word. I would not sort of use that sort of color to apply to that. I would just, it would be factual, right? Because what's the essence of that, of other act case law is, right, what's the act and how is it tied to relevance? That's really sort of editorial.
Okay.
Abandonment.
What else?
What else? In response to that happening, right, so Mrs. Hillygus goes with Robin, sort of a dispute or disagreement as to what should happen next arises, and in revenge, the defendant then makes up or calls Aging and Disability Services and makes what turns out to be a false claim of abuse and neglect of his mother while in the care of Robin Renwick. Relevant?
Well, they investigated, and your view is that was pretextual, there was nothing wrong, they concluded that there was no abuse occurring, right?
Right, well, I would expect the testimony today to be that the allegation appeared to be motivated by revenge or financial gain. That being testimony from the investigating person. So that shows, right, if the claim in his statement, and we have heard this echoed by Mr. Hanke, and this is mostly as the court is aware, he continues to engage in these extracurricular YouTube videos, this claim of rescue. Here is evidence to refute that when it's clear the defendant knows how to make a claim that an elderly person is being abused. Right? He knows the exact agency to go to. Department of Health, Aging and Disability Services, which conducts investigations, and of course the court has before it the reports, of that investigation. As well, going to motive, right? This it supports the sort of the motive as I've outlined, sort of financial motive for the mother. I've also requested limited evidence.
What?
It should be limited evidence of. It took 3 times to evict the defendant out of the home owned by the trust. So he
I agree with you.
that would come through a number of deputies were present to try to evict him, and importantly, I've outlined is he calls the house his house, right? Which clearly was not by operation of law. Clearly, I think he knew, and again underscores his motive. And I think I footnoted here for the court. Months prior to all this happening on YouTube, the defendant made a statement that the only way around guardianship is to flee the state or flee the country, right? So this sort of goes to his underlying intent or motive, right? He, now going back to this eviction, wants the house, right? Has a financial motive. He also was found in possession of $10,000 cash when he was arrested in California. Again, this sort of underlying financial.
Your theory
motive
from
for
the
himself.
15,000 that was withdrawn, or it's
That's my, yeah, and that's, right, that's sort of a weight versus admissibility, but yeah, I think that is a clear sort of line and reasonable line to draw. Also from this eviction aspect, that when the deputies were sort of dealing with the defendant and speaking with him, this is in Exhibit 3, page 2785, he claimed it was an illegal eviction, right? Throughout this hearing and within the case in chief, right, he also makes claims that, everyone is corrupt, the court has no authority over me.
Yep.
This eviction, sort of this thread goes from well before this eviction, but including this eviction, and goes to his motive. Essentially, every time he's been to court regarding a civil matter, he's lost, right? And so in revenge, or sort of to get back at or circumvent the orders of the court, he claims they're illegal. And so that claim within this eviction process that this is illegal and that you lack authority over me is relevant in case in chief. Another area that I seek to admit judges, I attached the report of Detective Sergeant Jackson Buell, a report from March 6th of 2018, in which the defendant had submitted a list of grievances claiming, among other things, that the officers who evicted him, that numerous judges, numerous lawyers in the community tied in with his guardianship and probate issues were criminal and demanding an investigation of them. Motive. This goes directly to motive, right? That being legal revenge, right? Revenge or a motive to circumvent the numerous lawful orders regarding matters involving the guardianship and probate. Additional aspect of this report that I wish to introduce is the conclusion or the observation of the officer that these, that's right, things aren't going your way. He makes a false claim as sort of revenge for not getting his way, but the conclusion that this is strictly a civil matter, and quoting the detective sergeant, an attempt to abuse or circumvent the legal system, right? If the question core to this, right, I think before the jury is, well, can't a person take their mother out of a nursing home? Why? It's his mother. Now that will be supported by the Trevinian piece, but also here, right? Evidence that the defendant's true motive and intent is to abuse/circumvent the legal system. A third aspect of this report being that sort of term of art, this being a civil matter. Now within the case in chief of the state is, on the day this happens, the defendant and a uncharged co-conspirator go to Reno Police Department sort of demanding to speak with the chief of police. This was sort of the road being paved by Mr. Hampy. Out comes a sergeant and explains to them this is a civil matter, right? And meaning, so the meaning of civil matter, right? So the defendant, and we've seen this in his pleadings, and frankly, I'm okay if the court waits until he does this during his opening statement or his voir dire or any place within this case, but it's expected, as he has done numerous times, saying this is a civil matter, meaning he believed that meant he could engage in self-help. Legal matter means go do, or civil matter means go do whatever you want. Of course, that will be flushed out with this officer, but if he has
Yes, they're being tried together.
evidence of 2 prior times he's been told this is a civil matter, and more specifically, civil matter meaning go work it out with the civil judge. Go ask a judge to rule on your case and see things your way. So this conclusion back in 18, this is a civil matter. This is a civil matter, Mr. Hillygus, meaning get you to a court, not go engage in self-help, right? Do whatever you want. Admissible under 48045 as to knowledge, lack of mistake or accident, absence of mistake or accident. Secondarily, I've asked for another report. This is dated September 7th of 16. And the author of this report is Richard White, an employee of the Sheriff's Office. Another instance of false claims. So I think that across these false claims, many of them should be admitted against sort of this revenge motive. This revenge, his intent is, right? You can't beat the person, you sort of try to undermine them by filing. Here's another instance of a false police report. This is related to the eviction. So he is evicted lawfully, takes 3 times. And he's evicted so that the trust can take the house, right? Can inventory the assets. And by that time, there's a new trustee, a professional one, to sort of to get a sense of what the trust, the size of the assets of the trust are, and be able to care for Mrs. Hillygus. So within that, they have to use a SWAT team, right? They have to go to the
Wait, I don't remember this. They had to use, like, I remember they had. I remember there was like an issue of them being barricaded when they fled to Los Angeles with his mother. I don't remember the situation where when he got evicted from his mother's house, it wasn't his house that he claims it was. The house was under the trust, the trust for the mother. I didn't realize that they needed a SWAT team to get him out of the house. I maybe I forgot that bit of information.
SWAT team, and they go in and the guardian inventories the assets of there at the house. It includes firearms and it includes vehicles, etc. In revenge, and here's my relevance argument, in revenge he makes a report saying they stole my guns, they stole guns, they stole the car, these criminals being the guardian and the deputies. And so another instance of sort of legal revenge. That's one relevant aspect of that. The second relevant aspect being it's concluded and it's told again to Mr. Hillygus, sir, this is a civil matter. You need to get to a civil court and resolve this dispute within that system. Again, refuting this claim that what the sergeant in this case, in the case in chief, said means go engage in self-help. So that's another knowledge sort of prong to catch on. It should be added, it is mentioned in that particular, in the report of Buell, that so Buell did an investigation and learned, because the 18 one was also a complaint about the eviction, that the firearms were still being held by the professional guardian, right, following orders of the court.
The trustee.
Yeah, I'm sorry, the trustee, Your Honor. But that Mr. Hillygus had filed a claim with the insurance that the firearms had been stolen and been in fact paid out for them. Sort of a rather obvious and on the nose instance of fraud. Now that.
Oh no! Oh no! Fraud! Okay, so fraud or crimes of deceit or deception are easier to bring in terms of prior bad acts evidence, because those types of crimes goes directly to attack the credibility of the witness. So like if you cheated on your taxes, committed wire fraud, or in this instance where the state's attorney is saying that he fraudulently filed an insurance claim for his stolen guns, despite the fact that the stolen guns were actually confiscated lawfully confiscated by the guardian, that may be a prior bad act that could go through and be brought in for the jury.
In this case, that aspect of that report, simply because there's no clear connection unless the door gets opened. So in summary, that's what I would expect with the witnesses that I have here today to present.
Well, however this motion goes, after I hear from the defendants, and give it more thought, if for whatever reason it doesn't work its way into the order, whatever the court's ultimate decision is, I'll state it clearly now, there'll be no evidence in this case brought up of any purported or attempted insurance fraud. Okay, all right, let's continue.
Okay, so they're saying, the state's attorney saying that is something that we would like to bring in if Hillygus brings up any instance that his guns were stolen or anything like that. So basically, the state's attorney is saying we want to hold that bit of information in our back pocket, just in case Hillygus decides to bring up a notion that his firearms were stolen or unlawfully taken or something like that. I think that's what they said, and I think that's what the judge said. Basically, they want to wait for Hillygus to open the door.
So that sort of, in summary, is the evidence I seek to admit. And I would ask the court to sort of reflect on both the burglary and the kidnapping. There's specific intent crimes, and that sort of makes the intent all that more sort of important in this case. And stepping back a bit, right? Like, so every time we're in court, we hear sort of claims that this court has no jurisdiction or no authority over the defendant, Hillygus. That is, so this case is an extension of that. So we ought not be able to sort of hide or sort of wash that away when, from the inception of the guardianship case, he has repeatedly shown sort of this revenge against the court or defiance of court orders as a motive. And that is incredibly relevant to this case. The question, I guess, looms within 48045, sort of what is the character inference of these acts? And I submit that in many of these, the character, many people, like for example, the family court stuff, many people go to court, have litigation in court, and the judge rules for or against them. There's no having had a ruling go against you in civil court, there's no there's no character sort of inference that flows from that, because we have an entire system developed, devoted to go resolve disputes. The court makes legal findings and factual findings as well. So I submit as to that, there's really very low sort of character inference available from there. And I would state
So don't let that trip you up, Judge.
Yeah, right. I mean, that's right. The court is balancing character inference and unfair prejudice. The question of whether prejudice is fair is is to the court to decide and solve legal for it. I'd also note that this motion is made with a sort of understanding of where I expect the case to go. Of course, the defendant may open the door with, or either defendant really, but I'm really focused on Mr. May open the door to the relevance on some of these, and really says nothing about this idea of if Mr. Hillygus testifies, that opens a whole other aspect of sort of bias, sort of vanilla impeachment.
Okay, I understand the state's position.
Thank you, Your Honor.
Thank you, Mr. Hillygus. I hope you're taking good notes. There were
Oh boy, here we go.
9 different areas where the state is asking the court to rule now that it can introduce evidence in its case in chief in an effort to assist it in proving its case with evidence beyond a reasonable doubt. You heard it summarized. It's in the motion. You heard explanation. You may respond to some or all of those.
What it appears that they're trying to do here is add more days and many, many, many more witnesses and many, many more documents and evidence, because they want to basically relitigate the whole civil matter. This was all a civil case, a civil matter. And I had asked for a jury 5 different times to have this case heard by a jury. In the civil court, the court lacked jurisdiction from the very beginning.
Oh, no.
Because my mother,
Hold on, you got it?
pen fell apart.
Deputy, do we have another pen by any chance?
It's working now,
Okay.
yeah, just it came unscrewed.
Okay, go ahead.
My mother and father, it's proven through documents by physicians, lacked capacity way back in 2012, 2013. They were evaluated by medical professionals that determined that they lacked capacity. So the court and the petition that was filed is in violation of NRS 65 because they were never provided guardian ad litems. They could not enter into a contract with their attorney to represent them because they lacked capacity.
So far, this isn't soft sit. This isn't a soft sit situation. Right now, he's box truck again. Thank God you aren't gaming today. On sub for a long time because of that. Okay. I hate to break it to you. But you know, if you want to unsub because you don't like me gaming, I mean, just unsub. I just because I'm not whatever. Give it one second. Anyway, where was I going? So right now I see so far I'm giving him the benefit right now because I see where he's trying to go here, but right now he's relitigating the civil case. So far there's nothing soft sit related to it. But he is effectively trying to relitigate the civil case.
So the court also lacked jurisdiction over individuals that lacked capacity when they had a power of attorney and a trustee. They didn't want this to come out in the court in a trial, but they maybe want to do this trial in this court, in a criminal case. But that's why the court in the guardianship and the probate cases lacked capacity over both of my parents. That there's physicians that said, these people, and it's sad, your parents, to see them be determined to lack capacity when they're still driving, but getting in accidents, having insurance claims, getting lost in a town they've lived in for 45 years, and to now try to help them and explain to them, you know, you probably shouldn't be driving. So the
Did they
court,
hire Mr. Turvina?
no, they did not.
Okay,
They didn't hire anybody because they lacked capacity to hire somebody. My parents.
okay, did they try to hire him, or did Mr. Turvina believe he was hired?
He charged my father after he was determined to lack capacity, and he's not submitted that to the court. I've got the records that Torvinen charged my father on his credit card after he knew that the doctors had determined that he lacked capacity.
Okay.
That is a crime. I've reported that crime to the Sparks Police Department. The person that they had that drew up their trust was Steve Moss. I don't see him as an attorney listed on their witness list, but I've got him on my
You
witness
can call
list.
him. If you
I've
want.
got him on my
Okay.
witness list, and
If you want him to testify, you've got to get a hold of him and have him agree, or you got to subpoena him, you understand that?
I
Uh-oh.
have filed a subpoena in this case, a professional, properly served subpoena for Deuces Tecum from the Department of Public Safety, DPS, and they did not provide the documents that were requested in the subpoena.
All right, let me.
You want me to handwrite a subpoena? They're not gonna respond to a handwritten subpoena. I need a subpoena from the court for the people that I need. And I've got quite a few witnesses, and I know they have quite a few as well, like close to 100. I've got 125. So if
125 witnesses.
basically, I'm now gonna have to add about another 25 to 30 witnesses that need to come in because he wants to basically relitigate this whole civil case that's 10 years old, as he has explained.
Let me ask you this. All right, you're giving the court a big picture, but before.
A little picture
Okay, well, you.
of a big scenario.
A little picture of a big scenario, and I understand your view.
I still have some other stuff.
No, go ahead.
So, I've submitted accountants. I never received a penny for taking care of my parents. They're my parents. I wasn't charging them, even though there was an order that said.
Yes. I mean, the onus would be on Ryan. The onus would end up being like shifted onto the party to justify that many witnesses. I mean, depending on the breadth and complexity of a trial, I mean, you could very well have 140 witnesses. It's possible, but the onus would be on the party bringing those witnesses in to justify to substantially justify the need for that particular witness to come in. Yeah.
Said I could receive payment. I deferred payment. I didn't need payment. I needed to make sure that that money was used for them and their care. I was willing to sacrifice and leave my house, that it didn't go into foreclosure.
I don't know what his max sentence could be.
Renegotiated the payment because I.
Hold on a second. Your Honor, I apologize. I think you might want to invoke the, I want to invoke the rule of exclusion for purposes of this hearing. There's a witness in here, Mr. Cordino. I know with respect, but I don't think it's proper that he be here now and hear everything that Mr. Hillygus is saying.
Mr. Trevino, if you're here, if I can have you please wait outside.
Uh-oh.
Oh,
Thank you.
The hell out.
Only we've twice now seen today, right? It's clear Mr. Hillygus is self-represented, and it's difficult. We all respect Mr. Silverberg and the position he has and his advocacy, but he is not an advocate for Mr. Hillygus.
Court can respond to invoke the rule of exclusion. I didn't actually see him there because he's right behind you, and I would have asked a question about him if I recognized him.
No, and I'm not, it's not that so much, it's this sort of assisting Mr. Hillygus as a matter of convenience, when really, of course, Mr. Hillygus' own strategy is up to him, and his sort of representation is his alone. I just ask the court to sort of
Keep an eye on it.
keep an eye on that, right? It's not like, well, you get to be helpful because it's helpful overall when you don't represent somebody.
Understood?
And just a very brief response. Whatever the court decides as it relates to Mr. Hillygus has an effect on Mr. Hillygus. So I'm gonna make a record about how, and I'm gonna cross-examine, and I'm gonna object to what I think is objectionable as it relates to Mr. Handy, because if all this comes in, Your Honor, I'm gonna be making a motion to sever.
Okay, I understand your position.
Thank you, Your Honor.
And Mr. Steggy, your concerns are noted. I'll keep an eye on it. If I think Mr. Silverberg is crossing the line there, I'll bring him back. All right, please continue.
And I did not know that he was here. I looked, and I did not see.
Mr. Hillygus, you didn't do anything wrong. This was
I would have objected to him being in
no
here.
problem. Then we figured out he's here. The court has excused him and directed him to wait outside.
All right, then. We all agree. We have agreements.
You didn't seek to get payment. These were your parents. You cared for them. You wanted to take steps that were to help them as they age, right?
That's correct.
Okay, but let me ask you this.
Stuart is Stuart Hanty. He's the co-defendant.
Mr. Steggy has said, Judge, I have evidence of several different areas, things, events, filings, reports, complaints, actions, inaction, that Mr. Hillygus took that is informative, backstory to, provides a basis upon which these acts that have now been charged put into perspective. The court, if it's going to allow some or all of this, treads lightly. The court needs to make a determination that the state has showed that these acts occurred by clear and convincing evidence, which is a standard beyond a reasonable doubt, the highest standard for conviction in a criminal matter, and more likely than not, civil dispute usually. So I have to make the determination, the state has convinced the court that that showing has occurred. Then I have to find it's relevant or otherwise is appropriate to be brought in. Then I have to find that it's not so prejudicial, unduly prejudicial to the defense, that it was essentially deprive you of a fair shot here. So I have a job to do. I'm going to take a look at this closely. But now's your time to say, Judge, this specific event is not relevant whatsoever. Or Judge, this specific event, if any relevance.
Yeah, he's trying. The problem that Hillygus is having, again, he hasn't gone soft sit yet. The problem that Hillygus is having is he's trying to relitigate the civil case, the guardianship, when the judge is trying to say, you need to argue that what went on during the civil case, the guardianship, is not relevant to the criminal matter at hand, and therefore the state cannot bring that in, bring the events of that guardianship to potentially poison the jury against me.
Is so prejudicial, it would just take the jury's view of things. Or judge, this thing doesn't go to anything relevant to what we're here to do. If you have those type of arguments, you've explained some things to the court, but please tell me now that I'm going to hear from Mr. Soderberg.
As far as the complaint to Elder Protective Services,
Yes?
that's irrelevant, it's prejudicial. There was complaints made against me that I cooperated with, but they're not including those because there was never any problem with the way that I was doing the care for my parents. My mother had to be placed under an alias in the hospital because she was being browbeaten by my father, who was trying to bring his girlfriend. Now they've been
Oh my
married
God.
for this 50 years, and now he had a girlfriend that he was trying to bring into the home. And my sister was constantly harassing my mother to make a list.
See, again, he started off saying like this is irrelevant and prejudicial, but now he's trying to relitigate the case.
Sticky notes on everything that she wants, and they're still living their life. Yeah, they've got issues with their cognitive decline, but that's not the time to start divvying up the assets. So my mother had to be placed into a hospital under an alias, and they're excluding that, so I would need that evidence. They're excluding the appeals that I filed at the time of some of these events, so that's another reason why these are irrelevant, is there was appeals going on. I was not properly served, because even though I was living in my mother's home, I was appealing any decision for her not being there, because I'd never been proven to be unfit. I thought it was just a no-brainer that my mother would be continuing to live in her home. I never abandoned her. I continued to fight for her. I wanted her back in her home.
Well, let's talk about the abandonment. You've already heard the court indicate that it's not, that's a pretty strong word here, and not one I'm likely to hear at the, during the trial, even if I let this in. And you heard Mr. Stakey say he probably, if the court allows this line of inquiry, will use a different word, approach, term. But the circumstances, as I understand it, were that your mom had undergone some medical procedure, and at some point you, according to the state, said or indicated or communicated that you were done or didn't want to or was not willing to. Now, if you say, Judge, it didn't happen that way, that's okay. So that may go to whether clear and convincing that it happened, or I let you testify about it and to put your side of it in front of the jury. Do you understand that?
I do. My mother did have pacemaker surgery, which took all of one day. The next day, she was released from the hospital, but under certain conditions that she needed to be, give the pacemaker some time to not come loose. Because my mother loved to be outdoors in her home, I agreed to let her go to my sister's home to recover for a week or two, and then come back to her home. I did not abandon her. She needed to recover from the surgery, and if she was at her home, she would be outside working in her yard, which she loved to do. And my wife and I didn't want her re-injuring the pacemaker surgery, so we said she can recover from the surgery, not abandon.
If I put you under oath right now, that what you just told me happened there, will you swear or affirm that would truthfully
Yes,
what happened?
absolutely.
Please raise your right hand, actually. You swear or
Oh,
affirm that
okay.
you just gave to the court with respect to the issue of potentially abandoning your mom after the surgery was truthful?
Absolutely true.
Thank you. You may put your hand down. Thank you. All right, what other issue here?
So, with respect to,
Judge, may I cross-examine on that?
In a minute.
Ooh.
Go ahead.
Uh-oh.
um,
Uh-oh. Oh, no! Well, you could be subject to cross-examination now. All right.
so
$15,000 withdrawal. Did that happen?
it did,
So,
to hire attorneys for my mother's representation. My mother was being represented at the time by Gordon Muir. He did not really do anything to benefit my mother, so I retained Keith Tierney. I, at the time, had attorneys that did not represent me properly. They did not want to go to a trial, nobody did, because they knew that I hadn't done anything wrong. That's my argument about this whole case, is it just continued to get
So let
pushed
me-
on down the
let me-
road. So I hired another attorney.
all right, and again, note you took a minute ago, with respect to the money you withdrew from the account, your intention was to hire attorneys to represent your
I
mom.
used it for that purpose.
Okay, they said that when, at some point, there was $10,000 either on you or in California, that was different money than the 15,000?
It absolutely was. It was, I'd sold a tractor, and that's all been documented through the
Okay.
LA, through Los Angeles, because they broke into my vehicle in LA without a search
Hold
warrant,
on.
without an arrest warrant, broke into the glove box and stole the money. And when my wife went to pick up the car, the hood flew up because they broke the glove box, broke the dash, opened the trunk, opened the hood. The hood flew up while she's driving down the freeway, caused $10,000 worth of damage to the vehicle because they were searching for weapons because they were told I was armed and dangerous. They didn't find any weapons. I was never armed and dangerous. And that money had nothing to do with that.
Got it. And the oath I gave you before with respect to explaining, after your mom had her pacemaker surgery, you answered under oath. Is it your truthful response to that issue?
Absolutely.
Okay. Let me ask you one or two more questions. Then I'm going to let Mr. Silverberg be heard on this if you'd like to take a position. But then, because I had you testify to this, if you want the court to balance what you said against the state's burden to show by clear and convincing evidence, I have to put you under oath. And because of that, like you're testifying like any other witness up here as to that issue, Mr. Sticky gets asked some questions and you'll be under oath for that. But give me just a second here.
I just have
Oh, boy.
other things I
All right,
wanted
cool.
to put on.
Go ahead, and then I'm going to turn to Mr. Silverberg.
So with respect to
Hey, Larry.
trying to
Oh gosh, I didn't see guys. Hey guys.
through their trust and through their powers of attorney that
Sorry.
continue to go on. There was, and I'm sure you're familiar with this, Supreme Court Rule 252, a settlement conference. This case,
Hold on a second. But normally, what happens there is not subject to this court learning about. You understand? It's not, the trial judge is not supposed to be directly involved with those discussions. The closest I get to that is, I ordered you to one,
this isn't a civil case that I'm talking about. I'm talking about the civil case years ago.
well, even then, what happens in those Supreme Court settlement
I'm just
conferences?
saying, there wasn't one. It was ordered, the judge that was hearing the case was the one that had the settlement conference. So you know that that's illegal. So when he says that these are all lawful orders from the civil court, no, that should have never happened, and I objected to that. I objected to the judge taking off her robe and acting as the settlement judge when she was a trial judge.
Okay, that was in the guardianship matter or the probate matter?
It was in,
Mr. Sticky, where?
it was in, they were
There's a
combined.
guardianship, there was a settlement reached, which has been reached.
So I mean,
Hold on.
that's wrong
Okay.
by the rules. And another thing is.
Okay, give me your
One
last
other
point
thing,
then.
one other thing with the same judge.
Yes.
She held a contempt hearing, and that's also to be done with a different judge, as you know. And she held me in contempt for something that I wasn't in contempt of. And I objected to her having that authority because it should have been sent to a different judge for an order that she ordered.
Okay.
So I'm just trying to explain that it's not all just, these court orders aren't valid. I believe that they weren't, and there's absolutely some truth to the matter.
Mr. Silverberg, would you like to be heard?
Thank you, Your Honor. Briefly, I've sort of gone point by point.
Here we go.
With the state's motion, and I'll address each one briefly. if I may.
Sure.
So first of all, as it relates to Mr. Hillygus being removed from the guardianship, it's just not relevant to what happened 3 years, 4 years, 5 years later when he was concerned about his mom being in a nursing home. And there's been argued that he did so for financial gain, but what possible financial gain would there have been for him to take his mom out of a nursing home? It's not like he held her for ransom and said, hey, I got mom and give me money. So I think there's a real disconnect between what the state is proposing as relevant, and it's really not relevant to this case. It doesn't show motive. It's remote in time, and it's going to create, I think Mr. Hillygus was getting this, sort of a retrying of events that really aren't relevant to what Mr. Hillygus' intent was that day. And respectfully, I think this is why the state wants to go in all these different ways, is because it's pretty weak about what his intent was that day, and that he was somehow intending to harm his mother. Number two was the false reporting, and the state finds it relevant that Mr. Hillygus knew how to initiate an investigation, and that was also driven somehow by financial motive. I don't see how it's relevant. I don't see how that possibly has financial gain if he's making a complaint to the health authorities about the treatment his mother is getting. There's no financial gain for him. So I think that the state trying to show the relevance is both weak, and again, it's highly prejudicial. One more thing on that point. The reports came back as unfounded, not false, not bad intent. Just because it was unfounded doesn't mean that he acted in bad faith. And there's no evidence that he did. Third point the state wants in is the Washoe County Sheriff's Office investigation initiated by Mr. Hillygus. And at page 9 of the state's motion, he says that's another example of familiarity with how to initiate an investigation. And that somehow shows motive, and again, a request for some financial gain here. And that's a really big jump that the state is making. There's no evidence that because Mr. Hillygus initiated a complaint about the way things were happening and what was going on, and wrongs that he perceived were happening to him and his property, that somehow shows motive in this case. That was really number 3, that point. It was very, very remote and should be denied by the court. Number 4 was the abandoning of his mother. Your Honor has addressed that, and I think Mr. Hillygus has addressed that appropriately. I'm not going to add on to that. The resisting eviction. Again, that's years before this case arose. And there's been no showing that somehow there was a financial motive for wanting to resist the eviction as opposed to Mr. Hillygus wanting to be able to care properly for his parents, as testified to the court today. So I don't believe that should come in. And again, as I stated at the beginning, Your Honor, all this, I don't represent Mr. Hillygus, but whatever the court allows in as to Mr. Hillygus necessarily reflects on Mr. Hanty. Who's Mr. Hanty hanging out with? The jury, I can see what of it. Which is why I think if this all does come in, I will be renewing my motion to sever in this case, because it's highly prejudicial to Mr. Hanty, who was not involved in any of this. Didn't know Roger, didn't know the Hillygus family, didn't know anybody, and had nothing to do with any.
It does kind of actually suck that Silverberg is almost playing double duty because he's representing Hanty, the co-defendant, but he also has to like tiptoe around things that Hillygus says and try to run defense for any of the crazy stuff that Hillygus says because it can negatively reflect his client. So if he doesn't say anything.
Yet, until a couple weeks before.
When they met by chance,
Yes,
right? That's what I'm understanding the defense.
yes. By chance and lawyer's office. The fact that that this is a civil matter, and I'm not even exactly sure what I guess the state wants in there that Mr. Hillygus is repeating to say he doesn't recognize the authority of the court. I think that is not relevant to this case. It's just not relevant to what his motive was on the day that this happened. Where he recognizes it just creates a whole other sideshow for the jury. And it doesn't get us any closer to guilty or not guilty. And then the service of the civil lawsuit on 2 judges. No, the 2 judges? It's numbers, hold on, it's numbers, point number 7. In the service of a lawsuit, you know, we all enjoy the right to initiate civil proceedings if we think it's necessary, and if there are rights that need to be, wrongs that need to be corrected. And the fact that this was done by Mr. Hillygus, serving a complaint because he believes his rights have been violated, that is a civil matter. It has nothing to do with what happened on the day in question. And again, it's just creating this whole sideshow for the state to point at all these other things to show it absolutely is being offered for propensity. It absolutely is. Trying to show that Mr. Hillygus is somehow a bad guy.
Yep, kinda.
A few bits and pieces, as Mr. Hillygus brought up very eloquently. There's an order, but there's everything that led up to it. So are we going to open the door to just absolutely everything? That doesn't make sense to me, Your Honor, when the real question is, what was Mr. Hillygus' intent on the day in question? And nothing that the state is offering here helps us get closer to that. It obfuscates. And again, all this being said because I think it's going to have an incredibly negative impact on Mr. Hanty, who's seated right next to him. And the state's going to try to show, oh, they were all in this together, and they conspired, and they've done all these things. They didn't even know each other through any of this. So if the court was going to allow this in, again, I will be making a motion to sever because I think it is incredibly unfair to Mr. Hanty.
So, okay, so, well, we are still ahead of the trial, but I did hear that Hanty's attorney does plan on filing a motion to sever, which is probably in his best interest. And by sever, he means he wants this to be split into 2 different trials. Like, he doesn't want his client to be anywhere near Hillygus for this one.
Okay.
Very precious. Thank you.
Thank you. All right, here's what happens. We're gonna take a 10-minute leg stretch break. When we come back, Mr. Steggy can argue in response to what he's heard, and he can examine Mr. Hillygus. I'll remind Mr. Hillygus at that point, he'll be answering under oath with respect to the issues that Mr. Hillygus responded to the court on, and that's all. And then I'll decide whether I'll hear again from everyone. All right, I'll see everyone in about 10, 12 minutes.
Darn it. All right, so that was actually it. There we do have part 2 is there, and they do have the witnesses, but I think I'm going to have to save that for tomorrow, guys. I'm actually kind of tired, to be perfectly honest. I don't know yet. I could see a portion of what the state wants to bring in to be accepted, but it also wouldn't surprise me if the judge denied the state access, or denied the state the ability to bring in certain information. But I feel like I feel that the case can be made by the state that a lot of the motivations leading up to the kidnapping are going to be found in the guardianship matter. I feel like it can't be helped. So I think that's why I think the judge is going to allow some of it to showcase motive, which is allowable. It's like a lot of M's. Motive, modus operandi. There's a lot of different things that the state can bring in to show, to bring in prior bad acts, and motive is one of them. So we will see. But yeah, there's going to be 2 witnesses in the part 2. But I'm actually really tired, guys. But I will see you guys tomorrow. We'll try and see, maybe we could try a bit earlier on Friday. But I hope you guys have a good night. Hit that like button on your way out. Thank you, Biggin, for the raid. As always appreciated. And yeah, you guys have a good one. Take care, and as always, I appreciate all your support. Adios. See ya.